The defendant knew what conditions he must follow and abide by. He knew he was a convicted felon who was legally forbidden from possessing any firearm for life for any reason. Bears, squirrels, protection from burglars, or zombies makes no difference. We will go on the record in the matter 24 CF 143, State of Wisconsin versus Michael Winquist. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Winquist appearing in person in custody with counsel Eugene Harrington. We're set today in this matter for an oral ruling. The parties have requested that the court review and approve a plea bargain, a plea deal that has been presented. We are in victims' rights compliance.
Yes.
All right, we are in victims' rights compliance at this time. Although I'm going to be making an oral ruling right now, I'm only going to give you a gist or a brief summary of what my decision is. I have a full written decision that I will sign immediately after this hearing, and the parties will have access to. The reason why I am not going to submit it right now, or I'm not going to read the decision because it is 13 pages. So it gives much for the parties to review and to discuss, but I'm going to say this was a very difficult decision to make. I have in front of me allegations of very heinous crimes that cause significant and permanent physical and emotional harm to a person and left a juvenile emotionally scarred. I have two attorneys whom I respect thoroughly, who understand the law and know the facts of this case thoroughly, more thoroughly than I have been provided. I only have access to the facts in the criminal complaint, the statements made during the hearings by counsel, and the facts that as they are outlined in the defense's stipulated facts memorandum. A plea bargain requires a court to have thorough review of what it has in front of it. If a prosecuting attorney has agreed to seek a charge or sentence concessions, they must have the approval of the court, and the court must personally inform the defendant that the prosecutor's recommendations, that the recommendation, this joint plea bargain, is not binding on the court. This bargain, this plea deal, must also be evaluated to ensure that it serves the public interest. The court's duty and role is to safeguard the public interest, to substantially ensure the benefits and the advantages to the public. Deciding whether to reject a plea agreement is firmly within this court's authority and discretion. It is vested in me, the judge, and the circuit court to determine what pleas do serve the public interest without allowing the court to interfere with the prosecutor's authority when the prosecutor decides what charges to file and whether to file charges at all initially. There are certain factors that a prosecutor considers when deciding whether to file charges, and these factors somewhat overlap with the court in determining public interest in whether to accept a plea. These include such things as extent of harm caused by the offense, threat posed by the public or to the public by the suspect, the ability and willingness of the victim to participate, the disproportion between the authorized punishment of the particular offense or the offender, possible improper motives of the complainant, cooperation of the suspect defendant with the arrest and prosecution, the possibility of a likelihood of prosecution by another jurisdiction. That doesn't affect our case. Accordingly, these factors that a court must weigh when defining a public interest and what interest is involved, it varies from case to case. I must look at each of the facts and look at each of the cases separately. One appropriate factor for one case may not be something considered in another case. Things that the court looks at and reviews would be such things as viewpoint from law enforcement officers, as well as other things, which it's not an exhaustive list, but I must take into account the public's right to have crimes that are actually committed to be fairly prosecuted and to protect the rights of third persons. The court must evaluate the defense attorney's reasoning and arguments and recommendations and balance that with the public interest and with the prosecutor's arguments to seek a fair prosecution. Other components of a public interest that the court must consider include whether the defendant has voluntarily and intelligently entered into a plea bargain, whether a factual basis exists for a guilty plea, the general public's perception that crimes should be prosecuted, the interests of the victims, the court's ability to dispose of a case in a manner to commiserate with the seriousness of the criminal charges, and the character and the background of the defendant, and the plea's usefulness in securing a legitimate and important prosecutorial interest. It has been observed that there may be situations where the public interest might be better served by having a case tried rather than having it disposed of with a guilty plea. The court has reviewed the facts of this case, the information, the complaint, the transcript for the preliminary hearing, the defendant's admission of facts, and the defendant's memorandum regarding the public interest of the plea. I've also heard very thorough, thought out arguments by both attorneys and an impactful statement by the victim. The court wrestles with the notion of accepting a plea in totem. That means to accept the plea as it is fully presented to the court as a complete agreement. Standing alone, the amendment to count 1 may likely be appropriate and would meet the public interest consideration. The rest of the plea agreement causes skepticism and trepidation. The court has a responsibility under case law and its higher courts to reject a plea agreement that does not serve the public interest as a whole and not simply in parts. The plea agreement as extended and when compared to the allegations of the criminal conduct with the facts available to the court gives the court apprehension. What jumps out in the record is the nature of the facts within the criminal complaint and the preliminary hearing transcript regarding the specific allegations of the defendant's criminal thinking. His blatant, utter disregard for public safety, in addition to his complete and total disrespect for the law. There are situations, again, where the public interest is better served to have a case tried rather than accepting a guilty plea and disposing of a case if the plea agreement as a whole is not appropriate and does not meet the public interest. The essence of this case remains: the defendant was not legally allowed to consume alcohol due to being on active probation with an absolute sobriety condition. He frequently binges on alcoholic beverages and is often intoxicated. He cannot legally own or possess any firearm because he is a convicted felon. He either has been diagnosed with or shows symptoms of PTSD from his military service and other life traumas, and did not seek therapeutic or other medical services to address it. He is aware of, or should be aware of, his history of experiencing a sleepy, dreamlike state, which is unpredictable and has violent outbursts upon sudden awakening. And worst of all, he unlawfully keeps a loaded firearm next to his bed, and throughout the house has multiple other firearms stashed away. And he is fully aware of all of the above. The defendant's knowledge of the above, combined with the defendant's intentional conduct and behavior of disregarding the law and violating probation conditions, not only puts the community at risk, but also creates a safety hazard with the potential for a significant probability of death or injury to himself or others. Taking all into account, combined with the victim's allegation of the shooting, the court is concerned that accepting the plea deal as it has been extended would convey an undesirable message to the public, suggesting that the conduct is not as horrific and gruesome as it may have been. The plea would lack the deterrent effect needed to prevent others from engaging in similar serious criminal conduct and behavior. The court need not accept the plea offer as presented unless the court is convinced that the state and the defense with certain facts exist. If the district attorney is publicly stating that the state cannot prove in a court of law beyond reasonable doubt that an impartial and unbiased jury of the defendant's peers would find the defendant engaged in allegations related with each, and I am specifically stating each charged account or any associated subsequent or lesser offense, that would be one thing. However, with this case, the attorneys are simply informing the court that considering the facts and the evidence, count 1, first-degree intentional homicide as an attempt, is not the accurate charge, as the evidence points to a lesser included charge, and a more appropriate charge would be, as the parties have agreed, second-degree reckless endangering the safety with use of a dangerous weapon modifier. And that may be accurate and true. The court notes that as the facts are outlined in the case, the modifier is, for the most part, meaningless and does not increase penalties, sanctions, or otherwise. Additionally, as part of the plea bargain, the defendant would plead guilty to only 1 count of felon in possession of a firearm. The remaining 6 Class G felonies for a felon possessing a firearm would be dismissed and read in, along with the other misdemeanor count for operating a firearm while intoxicated. Again, the attorneys are not telling the court that the other 7 criminal charges cannot be proven beyond a reasonable doubt, only that count 1 is not accurate and it is not the correct criminal charge based upon the facts and the evidence of the case. The maximum possible penalty the defendant would face with the plea deal would be 12.5 years of incarceration and 5 years of extended supervision. Even if the matter proceeds to a trial, as it is charged, and if the defendant is found not guilty on count 1 as charged with no lesser includeds, if found guilty on the remaining counts and charges, the defendant would face a maximum possible penalty of 35 years and 9 months of initial incarceration with 35 years of extended supervision. This is a significant reduction in the incarceration length hanging over the defendant's head. The court is looking at all of the information and the arguments and hearing the impact of the victim and the impact of the juvenile victim. And in viewing the gravity of the offense, if the facts presented to the court are accurate and factual, this case is so serious and so severe that it would depreciate the seriousness of the offense and promote disrespect for the law if the court accepted the plea deal. Further, it would not promote a public interest or be a deterrent factor to others, even though the defendant is making concessions to plead to a serious charge and is accepting responsibility for some of his conduct and actions. The plea would not have the deterrence effect to prevent others from engaging in similar criminal thinking and a total disrespect of the law and the entire criminal justice system. The defendant was not only on probation at the time of these actions, but was also being monitored by the law enforcement and by probation with certain conditions and mandates. The defendant knew what conditions he must follow and abide by. He knew he was a convicted felon who was legally forbidden from possessing any firearm for life for any reason, no matter the reason or the excuse. Bears, squirrels, protection from burglars, or zombies makes no difference. The defendant is a convicted felon and has no legal right to possess a firearm for life. He intentionally disregarded that prohibition and spat at the legal system, believing he was above the law and could do what he wanted as he wanted. What happened that day was one of the most serious crimes that could have happened in a situation like this. The only worse outcome would be if the victim had died. Even though the defendant accepts the offered plea deal and admits to guilt, or would admit to guilt, thus eliminating the need for a trial, that is not a decisive factor. The impact on the victim must be viewed as well. The victim in this case is not opposed to a trial. Even if the defendant can prepay $10,000 or more in cash towards restitution, or could pay all of the restitution off at once to the victim, it is not a conclusive factor for the court or the victim. All components of this deal show that the defendant is not accepting the plea deal and admitting to guilt to limit the victim from public scrutiny, embarrassment, or trauma. Rather, the defendant is accepting this plea deal and would be admitting to guilt for his benefit and gain, the reduction of incarceration exposure. The victim and her son expressed that they would rather go to trial and have a jury of their peers determine whether the defendant is guilty on all charges rather than the court accepting the plea deal. The victims, in theory, could be re-victimized if the court accepts the plea as proposed. The state and the defense argue that there is inadequate evidence to prove and support count one as charged. The court is not making that determination. The jury is an impartial and unbiased decision-making body. The jury will determine the credibility and the believability of the facts, testimony, and evidence presented at trial. The state could request of the court permission to amend and file an amended information. If the matter does proceed to trial, should the jury find the defendant not guilty on count one, attempted first-degree intentional homicide as charged, without a lesser included offense presented, the victim must abide by and accept the decision of the jury. Even count one, not part of the equation, there remains 7 additional counts in the information. There is a possibility that the jury could find the defendant guilty beyond a reasonable doubt with the remaining 7 counts, thus increasing the potential sentence exposure to the defendant, leaving the court with a sentence determination. So as I have tried to outline and identify, the court is not accepting the plea deal as proposed. The court would consider any additional plea deals if they are constructed and gathered, but at least at this time, it's not received. Mr. Schmidt.
I understand. Thank you.
Mr. Harrington.
Judge, I would request that the court reporter prepare a transcript to expedite the transcript. The court, and also because this is dean appointment, would request that the court authorize me to inquire of appellate counsel for the purposes of interlocutory appeal.
Must do that in writing, and the transcript's going to say pretty much a lot of what is in my written decision, but you'll get both.
I need both. I need it expedited because the time for the request for interlocutory appeal is 10 days, if I recall correctly.
20.
10, 20, doesn't matter. It's a holiday week next week. And then one final question as it relates to interlocutory appeal and the evaluation of that as an option to the defendant. Will the court permit a second-degree reckless endangering safety with the firearm to be a lesser included offense to the count one as alleged in the information? If it goes to a jury, do we get to use that as a lesser included offense? It's kind of a premature question, but
It could be a premature question, but I may not have been as specific in my statement to the attorneys. The attorneys know the facts better than this court. Attorneys know the facts more in and out than this court, and whether or not, as it relates to intentional homicide, even as an attempt, whether or not the facts would be applicable or they would be able to meet each of the elements of that crime. As I stated, the attorneys have reviewed this. The attorneys have determined that second-degree reckless with the modifier may be a more appropriate charge. The state can always amend the information or can be a part of a different plea agreement, plea deal with other things included. Count one was not the issue for the court.
that raises another issue that I may have to consider for an appeal, but I understand. Thank you, Judge.
We're totally fine going through with a trial with all 7 counts or all 8, 9 counts as they've been charged. And the court is simply saying the jury, the unbiased decision-making authority who determines credibility and believability of the facts, as well as the testimony of the witnesses, gets to determine whether or not count 1 through 9, they find beyond a reasonable doubt guilt. As far as this court's concerned, we have a jury trial for count 1 through 9.
When's our next status hearing, Judge?
Whenever we set it, we're going to set it right now. We have a final pretrial September 4th, jury trial in October. What are you looking for with regards to status? How far out? And again, the case law specifically says the court has discretion to reject a plea agreement as is, and I'm rejecting it, and we're going to trial.
I agree. That's what the law says, Judge.
What are you looking at? How far out?
Do you want to revisit this 17 to 18 of July? You and I will revisit before then, but
Why don't we talk after this hearing? I think you might have heard things from Judge that she didn't say.
And you're going to get my written decision right here that says everything that I said,
sure.
everything I said. All right. So I don't have the ability to do the 17th or the 18th, but
The next week of the 21st, status, real short status.
real
We'll
short
we'll
status.
either come up with,
I can
a new deal or-
probably fit a real short status somewhere in that week that you're asking, but I have to look very carefully because I'm supposed to have a trial, but it is going to be most likely gone and I have other things scheduled. I could do the 17th. I have only a couple hearings scheduled.
what time, Judge?
My one hearing's at 2. How about 1:30?
1:30 works.
1:30 on July 17th. And if you're requesting a transcript, it must be in writing to the court reporter.
Can I send you an email?
All right, anything further?
Not for me.
Mr. Harrington?
Thank you, Judge.
Thank you. We are adjourned.
Weapons. They are stored in the same place. It's Miss Fickbone's home. She gets to control what's in her home. And him exercising control over one or the other and just having access to the others concurrent makes the most sense there. The possession of firearm to shoot the victim in the reckless injury conviction that resulted from the same should be concurrent to each other because they were part of the same course of conduct and because they're parcel of the same act. And quite frankly, I think they exacerbate each other. When you look at those two things together, the felon possession of firearm where you actually use the gun to shoot somebody and the fact that the reckless injury was shooting somebody in the head, they make each other worse, especially when you're not even supposed to have the gun. For those reasons, again, I'd ask for a total sentence of 17 and a half in, 10 out with max on the reckless, max on the felon possession of firearm, those concurrent to each other. And then for the firearms in the closet, max on those concurrent to each other, consecutive to the other grouping. Thank you.
Thank you. Mr. Harrington.
Thank you, Judge. Before I analyze pursuant to the McCleary factors, I want to add a little more context to the circumstance. And in the course of adding to the context, I must make reference to Ms. Fickbone. I want the court, I want Mr. Mick, Ms. Fickbone, and all of her friends here to understand that I am not in any way blaming Ms. Fickbone. She was the victim of a crime, a very serious crime, and she deserves everyone's sympathy and concern. But she's involved, was involved, and remains involved in the context that led up to May 31st, 2024. Mr. Schmidt suggested that the circumstances of that day were not predictable. They were not predictable that day. But the facts, the background and the facts made this tragedy absolutely predictable. First of all, let's look at the circumstances of Mr. Winquist and Ms. Fickbone. They were engaged in a presumably romantic relationship. This Fickbohm statement emphasizes that in retrospect, it wasn't romantic, it was abusive. Mr. Winquist has told me that in fact, he considered the two of them married. The initial video that I saw of an interview with Mr. Winquist and law enforcement showed him wearing a wedding ring. He wore that wedding ring for many months.
I need to stop. Is she leaving and vacating or just using the restroom?
I don't know.
I just need to ensure that I'm gonna still be in victims' rights compliance.
He needs to take a break.
Okay, we need to take a break.
Sure.
All right, let's take,
She doesn't want to hear this. Yeah, that's right.
okay, this part she doesn't want to hear, but then she'll come back.
Yeah.
Okay. Mr. Harrington, you may continue.
Thank you, Judge. He wore the wedding ring in jail for months. I can't tell the court when he took it off. He considered that they were married. They weren't, but he considered it. The court is probably aware that he received a substantial financial award because of the accidental shooting. And he, pursuant to the plea, or the PSI, he gave her $75,000 because he thought they were going to stay a couple. He needed expenses, the money to pay some expenses in the house. And they needed to make some repairs. They lived together. They shared the living expenses. They vacationed together. They enjoyed each other's company. As Mr. Schmidt noted, there was nothing on the couple days before May 31st of 24 that suggested that this event was going to happen. The discovery reflected that when in the month before May 31st of 2024, there had been flirting by email between these two. But there's one other thing that they did together that made this tragedy predictable. Right together. Right together. They consumed the most destructive substance in our society, alcohol. Michael's mother told the agent that her observation was that they played drinking games. Alicia Johnson, Ms. Fickbohm's son's girlfriend, opined that both Christina and Michael drank too much. They drank together. So that's the circumstance that makes this tragedy somewhat predictable. We in the court system far too often observe the tragedies that result from increased alcohol consumption. As people continue in that process, they drink more and more. They make poor choices. They engage in riskier behavior. If they continue with that risky behavior, usually that consumption leads to a tragedy, both in their lives, but oftentimes in others' lives that are just innocent bystanders. My example is the instrument of the tragedy in most instances is an automobile. This instance, the instrument was not an automobile, but it was a firearm. A Remington 870 12-gauge shotgun. So I also contend and argue that in this particular instance, the tragedy was predictable because of the circumstance, but the tragedy was also predictable when we look at the instrument that was used. During the search of the house after the crime, law enforcement discovered a number of firearms. They discovered the shotgun, which was out in the bush, and the child had thrown it there. They discovered a loaded handgun in the kitchen drawer. Loaded in that the magazine was in the butt, in the drawer. And that was Christina's handgun. They discovered in the basement closet behind a dresser a loaded Remington 30-06 rifle. They discovered a loaded .22 Marlin rifle and a loaded .22 caliber Mossberg rifle, all kept in the basement. So these folks were consuming alcohol and had loaded firearms in and about the house. The tragedy was predictable. The date was not. But the date was May 31st, 2024. All those facts came to head, resulting in this tragedy. Michael Winquist and Christina Fickbone had consumed alcohol beverage during the afternoon, and I'm making these factual statements on the basis of the discovery. They had consumed considerable amounts of alcohol. The discovery reflected that both Michael's blood alcohol, this was 0.215, Christina's was, and I'm not sure where I got this number. Christina's, per my notes, was 0.297. I don't remember where I found that, was in my notes. I rather suspect that I got that number from some electronic discovery that I received. They consumed the alcohol. They visited a neighbor. Christina was driving the motor vehicle. We don't know precisely the sequence of what happened because, according to the discovery, neither Michael nor Christina could remember a sequence of events. We do know that Michael had napped, had a bad dream, woke up, grabbed the shotgun, fired it, striking Christina in the head. He is the victim of this horrendous tragedy, no doubt. As noted, there are three factors the court must consider in sentencing a defendant: gravity of the offense, the character and rehabilitative needs of the defendant, and the need to protect the public. The gravity of an offense or offenses is generally a comparison of what the crimes are, what's the maximum penalty, and other penalties that the legislature has determined are appropriate for a certain course of conduct, the maximum penalty. And then the other thing we look at is what happened. There isn't any question that these are serious offenses. The maximum penalty for count 1, second-degree reckless injury, use of a firearm as a penalty enhancer, 12.5 years confinement with 5 years of extended supervision. Those are the maximum penalties. With respect to felony and possession of a firearm, the maximum penalties there are 10 years with 5 years of confinement and 5 years of extended supervision. Are not as serious penalty when you look at the public policy as determined by the legislature, but serious in any event. And they should, the count 2, second-degree reckless, should be more serious because it is based upon reckless injury. Whereas counts 3, 2, 3, 6, 7, and 8, possession of firearm by a felon are really status offenses. Although one could certainly argue that 2 is not just a status offense. And I concur with Mr. Smith that it should be held together or bound together with the sentence as to count 1. Counts 3, 6, 7, and 8 are status offenses because people convicted of felonies, whether it be felony non-support, OWI felony, or any sort of a felony, shouldn't possess the firearm. The legislature has made that policy determination, and it's appropriate. Suffice it to say, this is a serious offense because of what happened to Christina Fickball. Struck on the head, the shoulder, with after the shotgun was discharged. The impact on her life is profound and permanent. These are serious offenses. There is no argument about that. Character and rehabilitative needs of the defendant. Michael is now 31 years of age. He's a high school graduate. He honorably has been discharged from the United States Marine Corps. Some of the people interviewed by the Department of Corrections agent, one person in particular, and I don't remember who it was, and it doesn't matter, said that merely because he's a veteran, he isn't entitled to any break. Agree with that? Michael agrees with that. Michael agrees with that. Michael was a United States Marine, is a United States Marine. And Marines accept responsibility and adapt their life to accept that responsibility and serve their public. Michael received his first OWI when he was in the Marine Corps, and the PSI reflects that he accepted that responsibility. He lost pay, he lost rank, he worked hard, regained the rank, and eventually was discharged honorably from the United States Marine Corps. He was injured while on active duty, receives a 90% disability benefit from the Veterans Administration. He had been employed until he was the victim of the accidental shooting in 2021. He contributed to society. He contributed to the household. He was a substantial contributor towards the expenses of the household. And as noted, Ms. Fickbohm provided care for him in his rehabilitation. During the healing from the gunshot wound he received, he had too much time on his hands and money. And if we look at the course of his life, he began consuming alcohol at 12. It became problematic at 15. His alcohol consumption probably declined during his Marine Corps service. But after he was shot, he had too much time and the alcohol spiraled out of control. He was convicted of OWI 4, and that did change his life because it doesn't appear that he was particularly driving on May 31st of 2024. Michael didn't have a father figure growing up. His relationship with his own father was strained. He only saw him sporadically. His mom was a single parent and was working, and Michael and his brother really had to take care of themselves, discipline themselves, and had brotherly disputes. People learn their parenting skills from the parents that they have. There was much discussion in the PSI about Michael's disciplining of children. Michael's using a stopwatch to make the kids eat in a specified time. Judge, having been a United States Marine myself 50 years ago, that's what drill instructors did. Was it right? Then it was. Is it an appropriate parenting strategy? No. But that's where we're at. And Michael. Mr. Schmidt mentioned the PTSD-like trauma or diagnosis. The evaluator for the NGI evaluation diagnosed him with a trauma and stressor-related disorder. It may qualify as a mental disease or defect, but not sufficient not to an extent to support the NGI defense. The evaluator opined that Michael Lindquist may be appropriate candidate for mental health and/or substance abuse treatment. You know, that was an interesting opinion from the evaluator, but the court, Mr. Schmidt and I have all worked in this business for many years. And we didn't need an evaluation that tells us that when we look at all the facts here. Michael's not perfect. Made mistakes. He loved Christina Fickball. It was love. Michael does want the court to know that not everything said about him in the PSI is an accurate characterization. He is very much remorseful. The agent concluded that he had no remorse because sometimes Michael hesitated when he was answering questions. Victims, DOC agents, judges, prosecutors. Judges and prosecutors know this more than others. Clients are instructed by their lawyers to be very careful with what they say in jail to agents and others. When we started the PSI process, I told Michael to be truthful, to not blurt out answers to the agent's questions, and to take his time. Did that. And Ms. Lineweber drew those conclusions, but that's the explanation for his hesitancy and that sort of thing. Michael's going to read a statement. Ms. Fickbohm and her advocate outlined that Michael has never apologized. And again, that's at my recommendation. Any statement a defendant makes while has jeopardy can be used against him either at trial or at sentencing. One does not make statements that can create more legal issues when you're facing these sort of circumstances. I mentioned that, the characterization of Michael's relationship isn't entirely accurate. I mentioned that Michael wore the wedding ring. He has her name tattooed to his chest. He says that his name, at least one time, was tattooed to part of Christina's body. He gave her the $75,000 to pay her bills. He commingled his veteran benefit and paid a large share of the living expenses. He wasn't always employed, and he helped her, and she helped him. Specifically, he denies the characterization from his ex-wife. He tells me that that was not, at the end, a pleasant experience for him or her. She, according to Michael, holds a great deal of acrimony to him. As the court can see from the PSI, the children went back and forth between Wisconsin and Oklahoma, sometimes by legal order, and sometimes by come and get these kids, I'm tired of them. And that's her saying that to him and him saying that to her. And then when most at the time of this incident, the children were living with her. Finally, Michael admits these crimes, stands ready to accept the court's punishment. Protection of the public. That is that third McCleary factor. And we all know what the case law says. It says that if appropriate, community supervision ought to be the first disposition. Does Michael Winquist need to be incarcerated for 30 to 35 years, as many think, to protect the public? No, he doesn't. Is his underlying personality and substance abuse dependency issues so severe as to preclude treatment within the community? No, it's not. Would not imposing a period of confinement unduly depreciate the gravity of this offense? And there isn't any question that the answer to that question is yes. The profound impact on Ms. Fickbohm, the use of a firearm, possession of a firearm as a felon, all those facts suggest that there needs to be confinement here. It's appropriate now that I comment on a couple things that Mr. Schmidt said. And Mr. Winquist knew he had this post-traumatic stress type disorder. He knew he was consuming alcohol to excess, that he was an alcoholic, that he had substance abuse issues. He knew that he had bad dreams. He knew that the firearm was there. But we see people like that all the time. People that have substance abuse issues, they can't solve it in a day. It's not a logical question that they have in their mind. I'm a drunk. I'm going to go get cured, and it happens. That isn't what we see. General deterrence, in my opinion, doesn't work. If there's a severe sentence here, isn't going to change the fact that somebody else that drinks too much and that keeps loaded firearms in and about their house isn't going to have the same tragic circumstance. That isn't how general deterrence works. Specific deterrence, I agree with Mr. Smith. Specific deterrence deters this particular person from this particular behavior. So there does need to be a period of confinement to not depreciate the gravity of what happened here. Dramatic impact on the victim, continued consumption of alcohol, and the possession of a firearm. With that, how long should Mr. Winquist be confined? Department of Corrections has to count one. Department of Corrections, with respect to all counts, did not recommend a maximum penalty as to any of them. That sort of surprised me a bit. But the Department of Corrections, the agents, the supervisors are familiar with all the law that we have, everything we've talked about, all the dynamics of substance abuse, mental health issues, and the range of penalties for these similar type crimes. As to count one, the Department of Corrections has recommended as a maximum in their range, 8.5 years, 6.5 years of confinement, 2 years of extended supervision. As to count two, the department recommended 3 years imprisonment, 2 years confinement, 1 year ES, consecutive to count one. Then counts 3, 6, 7, and 8. The department continued with that, 3 years as to each, 2 years confinement, 1 year ES, but all consecutive to each other. I agree with the Department of Corrections analysis, with the exception is counts 3, 6, 7, and 8 should be concurrent with each other, but consecutive to counts 1 and 2. That's the analysis of the Department of Revenue, Department of Corrections. Their status offenses, the firearms for counts 3, 6, 7, and 8 weren't in the bedroom. They were downstairs, in a closet, behind a dresser, loaded. They were loaded. At no time during the investigation of this were those firearms tested to see if Michael actually touched them. There weren't any fingerprint analysis. There was no DNA analysis on the firearms. If you look at the photographs of the firearms, there was rust all over those things. They hadn't been cleaned. They hadn't been properly preserved. So there should have been some effort to investigate and determine if Michael actually touched them after his OWI 4th conviction. That's why I emphasize that these are status offenses. They were in the house. They were available if he wrestled around for them. He's a convicted felon. They shouldn't have been there, but they were. And that's the basis for those convictions as to counts 3, 6, 7, and 8. I urge the court to adopt the Department of Corrections recommendations, with the exception that counts 3, 6, 7, and 8 be consecutive to consecutive counts 1 and 2, but concurrent with each other. Judge, I started this conversation, this argument, with noting the tragedy. And it truly is a tragedy. Could it have been avoided? Yes, but it would have taken Michael to recognize his substance abuse. Did not. And we're here. And that's what this is for. On final note, Michael paid the $10,000 initial payment on restitution a couple months ago. He tells me he sent another check for $2,582.23 to the court just within the last couple of days.
It
The
was
restitution
confirmed.
request has been paid.
It has been confirmed that that has been paid. So what is the total, initial and total extended supervision you are requesting?
10 years, 4 years ES. 10 years initial confinement, 4 years ES.
All right,
Actually, 10 and a half years, Judge. I'm sorry.
okay.
6.5 on count one, initial confinement. 2 on count two, initial confinement. 2 on counts 3, 6, 7, and 8. Count 2 consecutive to count 1. Counts 3, 6, 7, and 8 consecutive as to counts 1 and 2, but concurrent with each other. We believe that satisfies the needs and is appropriate. I have calculated his credit days through today at 565 days, including today. Thank you, Judge.
So 564 because you don't count today.
564. Yes.
All right. Mr. Winquist, I'm now going to turn to you and give you an opportunity. Actually, I'm going to wait to see if the victim would like to come back in. All right, the victim is now back in the courtroom. Mr. Winquist, I'm now going to give you an opportunity to tell me anything that you would like me to know. This is where you can state anything that you've heard that's been inaccurate, or you can go into more depth about things that have been argued or stated or that are in the facts in this case. This is where you have the ability to show any remorse or anything of that nature. You do not have to give a statement today, but it is your only opportunity. If you are going to read something, please read it slowly, enunciate your words, and please speak into the microphone.
Okay.
You may begin.
Thank you. I would like to make an apology.
Harrington, can you please move the microphone closer to him? Thank you.
I'd like to make an apology to Christina. I'm beyond sorry for what happened that night. It's so unfair what happened to you, and I will regret that moment for the rest of my life. I think about it every day and hate myself. I would give anything to change the outcome. I'm deeply sorry and hope the best for you. I would also like to apologize to Donovan. You should have never had to deal with that trauma, that situation. Very sorry. And also to all your family and friends that I've had to take care of you because of my actions. I know none of this changes anything for you, and I will mourn this for the rest of my life. Sorry.
Is that all?
Yes, Your Honor.
Let me tender this to the court reporter so she can double check.
Yes. Would you like that filed as a document or just with the court reporter for record of the record?
You can file it as a document, Judge. Then,
Okay.
then it'll be there.
Then she has a copy, she'll get a copy, and then the court will have a copy. Okay, thank you. The court has reviewed the PSI multiple times. I've highlighted, I've taken notes. I've read this so that I could have a better understanding of you, Mr. Winquist, a better understanding of the victim, and victims here, as well as a better understanding of what happened or what people believe happened that day. Your attorney has stated, and the state has as well, the factors, the things that the court has to focus on when it comes to sentencing. Number one is the nature and the gravity of the offense. How serious is the case? Is this matter? I have to look at your character, your prior criminal record, anything, any rehabilitative needs or other things with you. I also have to look at the need to protect the public. And here it's twofold. It's the victims as the public, as well as the general public. Because I believe everybody can state that this is true, that alcohol and firearms is very serious. And it's a threat not only to the people in the near vicinity, but it could also pose a threat to people in the general public. That's why we have separate, firing a firearm while intoxicated and other crimes related. It's serious. The court also has to look at the effect on the victims. Again, your rehabilitative needs, any undesirable behavior patterns from you, your culpability, your age, your education, the history. And as Mr. Schmidt pointed on, as well as your attorney did, deterrence. There's two types of deterrence: general deterrence, to generally deter others from thinking about doing something similar. And there's specific deterrence, deterring you specifically from committing this crime and other crimes. I have heard and considered the arguments from both attorneys. I have heard your statement. I have read, again, the information contained in this pre-sentence investigation report. I have heard multiple victim impact statements. And it's a lot for the court to digest. You have admitted here to these very serious crimes through a plea agreement with the state. Count 1 was amended down from attempted first-degree intentional homicide, domestic abuse. It was amended to a second-degree reckless causing injury with a domestic abuse enhancer, as well as use of a dangerous weapon enhancer or modifier. You pled guilty to that offense, and you have pled guilty to 5 other very serious offenses of possession of a firearm by a convicted felon. When the court first tallied what prison time was originally hanging over your head, I arrived at approximately 130 years if the court did a maximum possible penalty. Because if you were to have been convicted of the original charge of attempted first-degree intentional homicide, domestic abuse, upon conviction, you may be sentenced to a term of imprisonment not to exceed 60 years. And then that was amended down to the second-degree reckless injury with the domestic abuse enhancer and the use of a dangerous weapon modifier, where the maximum possible penalty could be the initial 12.5 for the second-degree reckless, with the ability to increase an additional 5 years of initial confinement because of the use of the dangerous weapon and that modifier. All in all, due to the agreement that you've reached with the state, the plea agreement, you essentially avoided a life sentence if you were convicted on all of the original charges. Ms. Fickbaum does not have the same ability to avoid that life sentence. She will continue to live with this day in and day out, not only the emotional turmoil and effects, but the physical effects that she has and will continue to suffer from, which then leads to financial effects and other mental health effects and other things that will seep and continue to seep into her life for her life. And as she stated, you may not have killed her, but her life left her that day. And another thing that she has stated in the PSI is that now she is a shell of her life. She has no home, no car, no money. She cannot live by herself because she cannot manage bills. She forgets things. She falls. She has fear and anxiety. It is a life sentence for her. The primary dispute here today is not whether or not the court sentences you to prison. Both sides agree that this is a prison sentence. It would unduly depreciate the seriousness of the incident and the offense that has occurred. But here the court has to look at all of those factors and all of those things to determine what is an appropriate sentence in this case. Because the court must order confinement at the minimum amount, which is consistent to protect the public based upon the gravity of the offense and your rehabilitative needs. There's not a formula that does that. I can't type it into an equation and have it shoot out an idea of what is an appropriate sentence. And I know the Department of Corrections has something with their compass, some ability to do that. They don't just pull their numbers out of the air. And I know Mr. Schmidt made a comment as it related to your compass. I don't rely heavily upon the compass scores, and I'm not sure how thoroughly your attorney went over that with you of what that means or what that is, but I don't rely heavily on the compass rating or the score. I don't necessarily think it's evidence-based. I don't think that it gives a real idea of the defendant and their ability or lack of ability to stay crime-free. Here, your compass score showed a low risk, that you would be a low risk to commit more crime and violent crime. And that's coming from an incident where you had a gun, a shotgun, and you shot your girlfriend in the head. So that's where the compass really doesn't come into play, or I can't rely upon it heavily, especially because the compass in other serious crimes, such as child sexual assaults or offenders or child pornography cases, those individuals also generally show a low risk. So I can't gauge based upon that. What I have to gauge upon and what I have to look closely on is your history whether this is an aggravated incident, an offense, if there's aggravating factors. I have to look at your ability to rehabilitate, your ability to understand the seriousness of your actions, and not just your action in this incident. We all know that this is extremely serious. There are allegations of domestic abuse between you and the victim and you and your ex-wife. I don't have anything that confirms that. I don't have that you have a criminal history as it relates to that. I don't even have a criminal history of violence with you. It's all alcohol related for the most part, except for perhaps your 2018 conviction for obstructing an officer. But if I look at the underlying facts, I'm going to guess it probably had alcohol relation. And you're nodding your head up and down, so that tells me it did. You have an alcohol problem. You are an alcoholic. You cannot, you should not, in any way, shape, or form, ever touch a drop of alcohol. And I have to go to a statement made by your counsel as it relates to your operating while intoxicated fourth offense, fourth conviction, which is a felony. It was stated that OWI fourth conviction changed your life. I don't see it changed your life at all. Not one bit. You continued to drink alcohol while you were on probation. You continued to engage in other activity that you were prohibited from while on probation. The only thing your OWI 4 conviction changed your life in was it took away your right, your privilege, actually, your privilege to be able to operate a motor vehicle and have a driver's license, because it took it away for life. But I'm going to tell you, I don't believe for 1 minute that you didn't drive illegally after your OWI 4th conviction. Perhaps you didn't on this day, as your attorney said, because he said this changed your life because you were no longer able to drive, and it appears he wasn't driving the day of the incident. That's the only thing that it perhaps changed your life. Maybe you didn't drive that day, or we have no facts that suggest that you drove that day. But the fact that you couldn't abide by your probation conditions, the fact that you continued to drink alcohol after your OWI 4th conviction while you were on probation, the fact that you continued to possess firearms when you are a convicted felon, leads me to believe that you wouldn't follow the lifetime restriction of no driving or having a driver's license either. So I don't think your OWI 4 conviction changed your life. If it had, perhaps we wouldn't even be here today. I do know that that day did change the victim's life. It changed her son's life. It changed her entire family's life. She now feels like she is a burden. She's not the same person she was previously. And she feels she never will be. And I know that it was brought up in the PSI and was brought up in arguments here today and from the victim herself, that you were shot with a rifle during an incident. I remember that day not that day, but I remember that incident very clearly because that impacted your OWI third conviction in front of me. That incident occurred when you were at a bar. You were standing up outside or something like that. The individual was cleaning his rifle in a house across the street. There was a cord on the floor. He was walking with the rifle. Somehow the safety wasn't on and it was loaded. Those are no-nos. But he tripped and fell. The gun shot through his glass sliding door, shattered the door, went across the street, went to the area on the bar's property where you were and struck you in the buttocks. Accident. It was an accident. This incident was on purpose. It wasn't an accident that you picked up a shotgun, you pointed it at your girlfriend at the time, you pulled the trigger, and you shot her in the head. That wasn't an accident. No matter how many people don't remember what happened or the incidents that occurred that day, or what was going through your mind, that was not an accident. Yours was an accident. Your PTSD, if you have it, and that's been said that it could be from that, or could be from this or that or the other. Any trauma that you have suffered from your shot in the buttocks, completely, 100%, totally different than the trauma that the victim here suffers from. Because she had somebody who said, I love you. She had somebody who said, from the words of your counsel, you thought you were married. You wore a wedding ring and you pledged yourself to her life, to her betterment, to make her a better person and to have this life. And you picked up that weapon that you had no legal right to possess, and you shot her in the head. It was not a heat of the moment type of incident. We don't have anything that from the juvenile who was there, who heard fighting all day, who heard a huge fight, and then all of a sudden a shot. He was downstairs in the basement playing a video game. He didn't hear that. You have had alcohol issues since you were 12. I know that it's been stated that that's when you started using alcohol, and it didn't get bad until you were 15, and you didn't have a problem until 15. But I'm going to tell you, starting drinking alcohol at the age of 12 is bad. It shows an issue. And again, you nodded your head up and down. It is. That was the start of your downfall. And whether or not your consumption of alcohol decreased while in the Marines, which again is kind of hard to believe because of the stories I've heard of people in service. Even if it did, once you returned and you were honorably discharged from the Marines and you came back, that's when it started again, not from the date of when you got shot in the buttocks. Because again, I remember that because as I took your OWI third conviction and I was being lenient to you in that conviction and was going to allow you to not have to sit in the jail for the 48 consecutive hours by law you're required to do, to serve that on an electronic monitor because of your injury. I took your conviction, you went up to jail to be processed, and you blew a .2 something. You were beyond legally drunk when I took your OWI third conviction. So I had to redo that conviction to ensure that you remained sober. And no, I did not allow you to get out on monitor. That's where I found an error in the PSI. You had to sit in jail. I did not allow you to be released on monitor because that was serious as well. So your alcohol issue is what has gotten you here in part, because both sides have argued and stated that you ignored your issues. You ignored the things that were going on in your life and with you. You ignored your alcohol issue. You ignored the PTSD that you felt. You ignored the violent nightmares that caused you to have outbursts. You ignored all of these things. And it put others at risk. And again, I want to stress, it didn't only put the victim and her family and son at risk. It essentially could have, serious harm could have occurred to the public in general because of this. Alcohol and guns do not mix. And the fact that you were convicted of an OWI fourth offensive felony, you were told you were still on probation. You were told that you could not use or possess any firearms. That meant it's not all on Miss Fickbaum's shoulders because it was her house. You live there too. And as you said, you felt she was your wife. It's not all on her shoulders. You as the felon, you on probation, you are the one who knew that any weapons in that home needed to be under lock and key, or they could not be in that home. And you were not able to have access to that key. It's not all on Miss Fickbaum's shoulders because that was her home. You are the one who knew exactly that you could not use or possess firearms. Yet you did. And the argument or the statement made was you had the shotgun to use for self-defense. That is not an excuse. That is not a reason to have an exception for a prohibition to firearms. There would be if your life at that moment, you needed that weapon for self-protection because it was imminent and you were in a life-threatening situation. You were not. And as applied to you with an OWI fourth conviction, still on probation, extreme alcohol misuse and alcohol disorder, you had no judgment or no judgment to even be around firearms. Alcohol and firearms are dangerous and can be very violent. So as applied to you, that prohibition is necessary. And then you add all in your personal issues, the violence, the aggressiveness, the PTSD, those nightmares. On top of that, especially as applied to you, the prohibition is necessary. I do have to look at your rehabilitative needs and to see if you have the ability to rehabilitate, if you want to rehabilitate, if you want to change your life. Because this, as it's been stated or argued, that this has impacted your life as well. it's kind of like a shock again to the victim that it's impacted your life. Your freedom may be restricted. You may be incarcerated for a significant period of time, but one day you will be released, even if it is on extended supervision, and you won't be suffering from the lifetime effects that the victim is, not to mention her son. The trauma of having to hear the thud, knowing the thud when he came up was his mother, knowing she was shot in the head, not knowing if she was going to live, having the fear that you could have, in whatever state you were in that day, knowing, not knowing, shot him and killed him. How you've devastated his life and his relationship with his mother. She's not able to do activities or do things as much as she was before. He now feels like he has to protect her. He now feels like he has to be the one to care for her. He's a child. He is a child who does not deserve to have to worry about these things. And now he does for the rest of his life. I want to make sure that I have covered everything that I have highlighted. As I'm looking, I do want to point out that it's a miracle. And thankfully to all that believe in higher powers, it is a miracle that Ms. Fickbaum is alive. But what she suffers from daily is worse than death. I'm not going to even expand upon the statements made about the other domestic violence with your ex-wife or the things that I think are abuse, emotional abuse, and other things with your children, and the fact that you had them eat under a timer, because I don't have any real concrete information that either of that has occurred. Because you do state, and you have stated to the DOC agent, that you were never physically abusive to Ms. Fickbaum. You were never abusive. You were not a violent or abusive person. The PSI says that there is a lack of remorse, and I know that Ms. Fickbaum has stated that that is something that she has been missing as well, seeing a lack of remorse. Your attorney has stated that he has directed you not to speak about that. You did provide that here today in a statement saying that you are sorry for those actions and what happened. It shows some remorse. I'm not sure how much, but that shows some remorse. Now, in factoring everything together and looking at the totality of the circumstances here, and especially looking at the gravity of the offense, and not wanting to unduly depreciate that gravity and to find a term of incarceration to meet the court's objectives. The court believes that a sentence that would not unduly depreciate the gravity of the offense to fit the crime and the crimes that have occurred. And especially because the court views the fact that you were on probation, you had a no drink of alcohol prohibition, you had a no firearms prohibition, and that one's for life. The court finds that that is an aggravation of this incident, and it aggravates what happened that day. And although Ms. Fickbaum may have engaged in
what starts as a simple court status conference quickly turns into a powerful reminder that the justice system can sometimes focus on rehabilitation instead of punishment. First, Keith Johnson appears before the court after his attorney explains that a possible resolution has been reached. The proposed deal would require Johnson to complete an alcohol course and write an apology letter before the case could be resolved. The judge gives him time to complete those requirements and schedules a future plea and sentencing date. It is a clear example of the court giving a defendant an opportunity to take responsibility and address the issues behind the case. But the next hearing brings an even more personal moment. Lee Rogers appears by video while waiting for his attorney, and the judge even gives him a lighthearted Zoom 101 lesson on how to mute and unmute himself. Once his attorney arrives, the conversation turns serious. Rogers has recently completed a treatment program and still needs time to review the discovery in his case. Then comes the moment that changes the tone of the entire hearing. Rogers tells the judge that he has been sober for 60 days, the longest period of sobriety he has ever achieved.